The Supreme Court shocked RV owners in January 2026 by confirming that states can revoke RV registrations.
Opinion on the court saying today that the city's camping ban does not amount to cruel and unusual punishment and does not criminalize homelessness, but advocates for the homeless.
Vehicles that were once legally registered are now under review, and many owners are scrambling.
It clears the way for those that already have bans in place, and it'll most likely embolden those that were considering bans but maybe hesitated to do that.
Why were RVs singled out? What does this mean for long-term travelers? Join us as we uncover the truth behind this major change. The January 2026 Supreme Court ruling. What exactly was decided? The issue that reached the Supreme Court did not begin as a single sudden fight in January 2026. It grew out of more than a decade of repeated disputes between state motor vehicle agencies and vehicle owners over how registration rules should apply to recreational vehicles. These disputes had appeared in dozens of lower court cases across the United States, most of them involving residency claims, domicile definitions, and how an RV is classified for legal purposes. By the time the Supreme Court agreed to hear the matter, versions of the same question had already surfaced in multiple federal circuits and many state courts, creating inconsistent outcomes that regulators said were impossible to manage. The conflict started when state motor vehicle departments began tightening compliance checks tied to federal data standards. All 50 states are required to keep accurate vehicle records for insurance enforcement, taxation, and law enforcement coordination. Over time, audits showed that RV registrations were far more likely than standard passenger vehicles to involve unclear addresses, non-resident filings, or use classifications that no longer matched reality. Passenger cars rarely trigger these problems because they are tied to stable residency. RVs are different because they can move constantly, be used seasonally, or function as long-term equipment rather than daily transportation. States argued that this difference mattered. An RV registered as a recreational vehicle but used continuously in one jurisdiction raised questions about tax responsibility, inspection standards, and enforcement authority. Several states reported that a large share of registration disputes involving residency involved RVs rather than cars, even though RVs make up a much smaller portion of total registered vehicles nationwide. This imbalance pushed agencies to seek clearer legal authority. The legal question placed before the Supreme Court was narrow but critical. The court was asked to decide whether a state may deny, suspend, or revoke RV registration when the owner no longer meets residency, domicile, or declared use requirements, even if the registration was valid when issued. A second part of the question asked whether federal standards prevent states from taking corrective action once a registration has already been granted. The court examined long-standing principles of vehicle regulation. Registration has always been administered by states, not the federal government. The court reaffirmed that vehicle registration is an administrative approval that depends on continuing compliance with state law. It is not a permanent entitlement that freezes facts in time. If the facts that justified the registration change, the approval may be reassessed. In its decision, the court allowed states to enforce their registration laws as written, including revoking RV registrations when documented requirements are no longer met. This includes cases involving insufficient proof of residency, failure to establish lawful domicile, or misclassification of vehicle use. The ruling confirmed that states do not need new legislation to act when existing standards are violated. At the same time, the court placed limits on state power. States are not allowed to revoke registrations randomly or without structure. They must rely on written statutes or regulations, apply them evenly, and provide basic notice procedures. The decision blocked states from inventing informal rules or enforcing unpublished standards. A crucial part of the ruling involved the difference between revocation and non-renewal. Non-renewal occurs when a registration period ends and is not extended. Revocation occurs when an active registration is withdrawn before its expiration date. The court clarified that both actions are lawful tools when compliance fails, and that revocation is permitted when ongoing conditions are no longer satisfied. This clarification explains why existing registrations were affected, not just new applications. The court also addressed timing. The legal authority recognized by the ruling took effect immediately, but practical enforcement did not. State motor vehicle systems operate on annual cycles tied to registration renewals, compliance audits, and database updates. January is the point when many states begin large-scale verification processes. This is why the impact appeared sudden, even though the legal foundation had been forming for years. But if the court did not directly ban RVs, why did registrations begin disappearing almost overnight? Why RV? Registration was targeted and not other vehicle types. RVs often did not. Law enforcement accountability also played a role. Registration databases are used to confirm ownership, run plate checks, and apply local laws. When an RV was registered far from where it actually operated, enforcement agencies faced delays and uncertainty. This was not a widespread issue for trailers, boats, or commercial trucks because those categories have separate tracking systems and clearer operational rules. The court's interpretation of primary use became central. Primary use means how the vehicle is mainly used over time, not how it is labeled on paper. Travel use involves movement, temporary stops, and short stays. Residential use involves long-term presence in one place, regular utility connections, and ongoing occupancy. The court recognized that states may look at real-world use when deciding whether registration requirements are met. This interpretation did not redefine RVs as homes. It confirmed that when a vehicle's use no longer fits its registered class, states may require correction. That authority already existed, but was unevenly applied. The decision clarified that states are not required to ignore reality in favor of paperwork. Trailers, boats, and commercial trucks were excluded for clear reasons. Trailers are not self-powered and follow the registration of the towing vehicle. Boats are governed by maritime and waterway systems, not road use laws. Commercial trucks operate under federal and state commercial frameworks that already account for multi-state movement and primary use differences. RVs lacked such a unified system, making them the most vulnerable category. So, if classification is the problem, who now decides whether an RV qualifies for registration at all? How states are now legally allowed to revoke RV registration. State motor vehicle departments have always held the core authority to manage vehicle registration within their borders. What changed is not the creation of new power, but the confirmation and clearer use of powers that already existed under state law. Registration has never been a permanent guarantee. It is an approval that depends on continued compliance. When the facts supporting that approval change, the registration can be reviewed and corrected. State motor vehicle departments operate under statutes passed by state legislatures. These statutes give agencies the authority to issue, deny, suspend, or revoke registrations when legal requirements are not met. RVs fall fully under this system because RV registration depends heavily on residency, domicile, and declared use. Departments are allowed to verify those conditions at any time, not only at the moment of application. Revocation is triggered when specific conditions appear. One of the most common is the lack of verifiable domicile. A domicile is more than a mailing address. It refers to a legally recognized home base where a person has a real and continuing connection. States may require proof such as physical presence, local ties, or consistent documentation. When an RV owner cannot show a lawful domicile that meets state standards, the registration can be withdrawn. Another trigger is failure to meet residency duration thresholds. Many states require that a person live in the state for a minimum period before claiming residency for vehicle registration. This period may vary by state, but it is clearly defined in law or regulation. If audits show that the required duration was never met or was later lost, the registration becomes invalid. This applies even if the registration was approved earlier based on incomplete information. Inability to prove non-residential use is another key factor. RVs are registered under the assumption that their primary use is recreational or travel-based. When evidence shows that the RV is being used mainly as a fixed residence, states may determine that the registration classification no longer matches reality. Utility hookups, long-term parking patterns, or consistent location data may be used to support this finding. The issue is not living in an RV itself, but whether the vehicle's use still fits its registered category. Enforcement happens in two main ways. Automated audits are increasingly common. These rely on databases that compare registration records with insurance files, tax records, address systems, and other state or interstate data sources. When inconsistencies appear, the system flags the registration for review. This process allows states to examine large numbers of records efficiently. Manual enforcement also remains important. This includes direct reviews by agency staff, responses to reports from other departments, or findings from inspections and roadside checks. Manual enforcement is slower but allows for closer examination of individual cases. Both methods operate under the same legal standards. One area that causes confusion is retroactive application. Retroactive does not mean punishing past behavior. It means correcting a registration that is currently active but no longer valid. If a registration was issued based on conditions that later changed, or information later found to be incorrect, the state may cancel it even before its expiration date. This is how previously valid registrations can be canceled without new laws being passed. Notice requirements are an important safeguard. States must provide basic notice that a registration is being reviewed or revoked. This usually includes written notice explaining the reason and the effective date. States must also provide information on how to respond or appeal. However, states are not required to hold hearings in every case, and they are not required to provide extended grace periods unless state law says otherwise. So, once a registration is revoked, what actually happens to the RV in legal terms? The administrative chain reaction after registration revocation. When an RV registration is revoked, the effect does not stay inside a single office or a single database. Vehicle registration sits at the center of several connected systems. Once it is removed, each connected system reacts in sequence. This chain reaction explains why revocation feels fast, wide, and difficult to stop once it begins. The first system affected is insurance. In most states, active vehicle registration is legally tied to active insurance coverage. Insurance companies regularly confirm registration status through automated checks. When a registration is revoked, that information is transmitted to insurance verification systems. Once the link breaks, insurers may suspend or cancel coverage because the vehicle is no longer legally registered for road use. This does not require a separate decision by the insurer. It is often automatic because the policy depends on legal registration status. Inspection systems are affected next. Many states require periodic safety or emissions inspections as a condition of registration. These inspections are logged into state databases that connect directly to registration records. When a registration is revoked, inspection records lose their legal effect. A valid inspection without valid registration does not restore road legality. This creates a situation where even recently inspected RVs are treated as non-compliant. License plates are directly tied to registration records. When registration is revoked, the plate number is flagged as inactive. The plate does not disappear physically, but legally it no longer authorizes road use. This status change is immediately visible to enforcement systems. The vehicle identification number is also marked to reflect the revoked status. This ensures that even if plates are altered or removed, the vehicle itself remains traceable. Law enforcement databases respond quickly to these changes. Plate readers, traffic stop systems, and roadside scanners rely on real-time or near real-time data. When an officer runs a plate or scans a vehicle identification number, a revoked registration appears as an alert. This does not mean the RV is seized automatically, but it does mean it is no longer lawful to operate on public roads. The system treats it the same way it treats any unregistered vehicle. Financial consequences follow closely. Many states impose penalties when a vehicle is found operating without valid registration. These penalties may include fines, late fees, or administrative charges. Reinstatement fees are common and can accumulate quickly. In some states, reinstatement also requires proof that the original cause of revocation has been fully resolved. This may include updated residency documentation, corrected insurance records, and reclassification of vehicle use. One of the most misunderstood effects is how revocation spreads across states. Vehicle registration systems are no longer isolated. States share data through national motor vehicle information systems. When one state revokes an RV registration, that status can be visible to other states. So if states can share data, is there any safe state left for RV registration? Interstate data sharing and federal oversight. After the ruling, vehicle registration in the United States appears local, but it operates within a shared national framework. States control registration, but they do not operate in isolation. Over time, data sharing between states has expanded to improve accuracy, enforcement, and fraud prevention. RV registration is fully embedded in this network. National motor vehicle databases play a central role. These systems allow states to exchange information about titles, registrations, vehicle identification numbers, and status changes. When a registration is issued, suspended, or revoked, that update can be accessed by other participating states. This prevents duplicate registrations and conflicting records. It also ensures that vehicle history follows the vehicle, not the owner's location. Federal standards influence how these systems operate, even though the federal government does not register vehicles. States must meet minimum requirements for record accuracy, identity verification, and data consistency. These standards exist to support law enforcement coordination, insurance enforcement, and transportation safety. When states fail to maintain accurate records, they risk losing access to shared systems or federal support. Because of this structure, moving an RV does not reset registration eligibility. Physical relocation does not erase the vehicle's administrative history. When an owner applies for registration in a new state, the vehicle identification number is checked against national databases. Prior revocations, suspensions, or compliance flags are visible during that review. The new state may ask for additional documentation or deny registration until the issue is resolved. Cross-state enforcement works through information, not physical control. One state does not enforce another state's laws directly. Instead, it uses shared data to decide whether its own registration requirements are met. If a vehicle carries unresolved issues from another jurisdiction, those issues affect the new application. This process is lawful and routine across all vehicle types, not just RVs. The idea of registration shopping relies on outdated assumptions. In the past, inconsistent data sharing allowed vehicles to move between states with little oversight. That environment no longer exists. Modern systems are designed to detect patterns such as repeated re-registration, address inconsistencies, and unresolved status changes. RVs attract attention because their movement patterns are already unusual compared to passenger vehicles. Federal oversight does not mean federal control. It means shared rules for data integrity. States remain free to set their own registration laws, but they must operate within systems that value accuracy and traceability. RV registration now sits under the same scrutiny applied to other regulated vehicles, but with added attention due to its flexible use. The result is a system where compliance must be resolved, not avoided. Moving the RV, changing the state, or restarting paperwork does not remove the underlying issue. Only correction does. If relocation does not fix the problem, what options remain legally available? Keeping or restoring RV registration is possible, but only through clear and lawful steps. There are no shortcuts that work long-term. State motor vehicle systems are built to confirm facts, not intentions. When those facts are documented correctly and remain consistent over time, registration can be issued or reinstated. When they are not, applications fail, even if the owner believes they have complied. The first and most important pathway is establishing a lawful domicile. Domicile is a legal concept, not a preference. It refers to the single place a person recognizes as their permanent legal home. A person may travel widely, but they can have only one domicile at a time. States look for clear signals that a domicile is real and ongoing. This includes physical presence, intent to remain, and consistent behavior over time. Simply choosing a state because it is convenient does not create a domicile by itself. Residency documentation is the next step, and this is where many attempts fail. States require proof that matches their laws, not generalized documents. Common requirements include a state-issued driver license, voter registration, tax filings, lease or property records, and consistent address use across agencies. Each state sets its own list, but the core idea is the same. Documents must point to the same place and show continuity. A collection of unrelated papers from different states weakens an application rather than strengthens it. Time also matters. Many states require a minimum residency duration before allowing vehicle registration. This duration is defined in law and cannot be bypassed. If the required period is not met, registration can be denied even if all documents appear valid. Some owners misunderstand this rule and assume immediate eligibility. That misunderstanding leads to failed applications and later revocations. Another legal pathway involves reclassification of RV use. RVs are registered under the assumption of recreational or travel use. If an RV is used primarily in one location for long periods, states may require the owner to acknowledge that change. Reclassification does not turn an RV into a house, but it may change how it is regulated. This can affect inspection requirements, zoning rules, or registration eligibility. Reclassification must be requested openly. Hiding actual use creates future enforcement problems. Title restructuring is often confused with registration restructuring, but they are not the same. Title establishes ownership. Registration authorizes road use. Changing a title, such as updating an owner name or correcting a lien, does not automatically fix a registration issue. Registration restructuring involves meeting current legal conditions for operation. Some owners focus on title changes and overlook registration compliance, which leads to repeated denial. Appeals and administrative hearings provide another lawful pathway. When a registration is revoked or denied, states usually allow a limited window to challenge the decision. Even with compliance, why are some RVs still denied registration? Exemptions, edge cases, and misunderstood exclusions. Not every RV is subject to revocation. Some categories are clearly exempt or treated differently under state and federal law. Understanding these exceptions is important for owners and regulators alike, because many of the widespread concerns arise from misinterpretation of who is affected. Commercially registered RVs operate under business rules rather than personal vehicle rules. Businesses often purchase RVs for rental, leasing, or promotional purposes. These vehicles are registered as part of a commercial fleet. The registration process for commercial RVs follows different standards, often focusing on business address, insurance coverage, and liability requirements. Because the RV is not tied to an individual owner's domicile, these vehicles are not targeted under rules designed for private registration. This distinction is a legal line that remains consistent across states. Fleet-owned recreational vehicles are a related category. Governments, corporations, and large organizations may maintain fleets for travel, transport, or other operational purposes. Like commercial RVs, these vehicles are linked to organizational compliance rather than individual residency. Fleet management systems include insurance verification, inspection records, and operational reporting. These systems are structured to satisfy state and federal oversight, so fleet vehicles remain compliant even if used across multiple states. Temporary travel permits also provide a lawful exemption. Many states allow short-term registration or permits for visitors who bring vehicles into the state for limited periods. These permits are designed for travel and tourism, usually ranging from 30 to 90 days, depending on the state. Because the purpose of these permits is temporary travel, they do not fall under residency or domicile requirements. A private RV owner on a brief trip is therefore not subject to revocation as long as their stay remains within the permit period. Seasonal use exemptions are another recognized category. In regions where RV travel is common for part of the year, some states allow registrations tied to seasonal presence. These registrations assume that the RV is parked or used in the state only during defined months. The legal framework often requires proof of seasonal residence or temporary use, such as utility receipts or campground agreements. Seasonal registrations are not permanent, but they are not subject to the same revocation rules aimed at permanent residency misuse. Military and federal exemptions are also clear. Members of the armed forces, federal employees, and certain government contractors may register vehicles in their home state, even when physically located elsewhere. States recognize federal directives and provide exemptions to prevent administrative conflicts. These RVs are not subject to revocation due to changing location or temporary misalignment with state residency rules. Despite these clear exemptions, misinformation circulates online. Some reports suggest that all RVs, including commercial fleets, temporary permits, or military vehicles, were immediately revoked nationwide. In reality, the legal and administrative rules only affect privately owned RVs where residency, domicile, and use classification are in question. Misunderstanding of database flags, temporary registration lapses, or incomplete compliance contributes to panic and confusion. So, if exemptions exist today, will they survive future court challenges? Exemptions, edge cases, and misunderstood exclusions. States are expected to adjust laws and regulations in response to the ruling, and RV ownership will no longer be as flexible as it once was. Lawmakers and motor vehicle agencies are likely to increase requirements for proof of domicile, residency, and actual use. Minimum residency durations may be standardized, and documentation rules are likely to become stricter. States may also require notarized affidavits, utility records, or other verifiable evidence to confirm legal residence. The trend points toward greater scrutiny for any vehicle whose registration is tied to personal residency rather than commercial or temporary use. Inspection and compliance standards are also expected to rise. Safety, emissions, and operational inspections will likely be more closely monitored and tied directly to registration renewal. Agencies may conduct periodic audits to verify that the RV continues to meet use and domicile requirements. Automated systems will flag irregularities, but manual review may also increase to ensure compliance. Even small discrepancies could delay renewal or trigger revocation, making ongoing monitoring essential for owners. As a result, documentation management will become a routine part of RV ownership, not just a formality at registration time. Flexibility in registration will shrink considerably. Previously, RV owners could exploit differences between state laws to register vehicles in multiple states or maintain registrations while living primarily elsewhere. With national databases, shared enforcement, and clear legal authority for revocation, these practices are now riskier. Owners will need to maintain a consistent legal domicile and primary use record. Moving to another state will no longer automatically reset compliance. Registration rules will increasingly require consistency, accuracy, and verifiable proof of ongoing compliance across jurisdictions. This ruling is reshaping RV ownership models. Full-time RV living, long-term residency in vehicles, and multi-state registration strategies are now subject to strict review. Ownership models that rely on temporary addresses or mail forwarding solutions will need adjustment or replacement. Owners who rely on seasonal residency must clearly document the limited time spent in each state. Compliance will become an integral part of vehicle management rather than a secondary concern. Companies providing RV rental, leasing, or shared use programs may also need to verify that individual renters meet residency and usage requirements to avoid liability for non-compliance. Beyond RVs, this decision sets a precedent for how states can enforce vehicle registration rules in other categories where primary use and domicile may be ambiguous. Vehicles with dual functions, movable structures, or multi-state operation may face similar scrutiny in the future. Lawmakers may look at boats, trailers, tiny homes on wheels, or commercial vehicles with mixed personal and business use. Enforcement frameworks could expand to cover these categories, using the same principles of verifiable domicile, primary use, and compliance with state-specific rules. The long-term regulatory environment is therefore likely to be stricter, more transparent, and more centralized. Owners will need to maintain accurate documentation, meet clearly defined residency requirements, and monitor vehicle use continuously. States will leverage shared databases, automated audits, and inspection data to ensure ongoing compliance. Enforcement will no longer be reactive but proactive, identifying potential violations before they escalate. But if RV registration is no longer just paperwork, but a legal status, what vehicle category could be next? If you enjoyed this video, like and subscribe, and also click the next video shown on your screen.